A barrister is a type of lawyer in common law jurisdictions who works at higher levels of court. Barristers mostly specialize in courtroom advocacy and litigation. Their tasks include taking cases in superior courts and tribunals, drafting legal pleadings, researching the philosophy, hypothesis and history of law, and giving expert legal opinions. Often, barristers are also recognized as legal scholars. Barristers are distinguished from solicitors, who have more direct access to clients, and may do transactional-type legal work. It is mainly barristers who are appointed as judges, and they are rarely hired by clients directly. In some legal systems, including those of Scotland, South Africa, Scandinavia, Pakistan, India, Bangladesh, the British Crown dependencies of Jersey, Guernsey and the Isle of Man, the word barrister is also regarded as an honorific title. In a few jurisdictions, barristers are usually forbidden from conducting litigation and can only act on the instructions of a senior solicitor, who performs tasks such as corresponding with parties and the court, and drafting court documents. In England and Wales, barristers may seek authorization from the Bar Standards Board to conduct litigation. This allows a barrister to practice in their dual capacity, fulfilling the role of both barrister and solicitor. In some countries with common law legal systems, such as New Zealand and some regions of Australia, lawyers are entitled to practice both as barristers and solicitors, but it remains a separate system of qualification to practice exclusively as a barrister. Differences between barristers and other lawyers. Differences: a barrister, who can be considered as a jurist, is a lawyer who represents a litigant as advocate before a court of appropriate jurisdiction. A barrister speaks in court and presents the case before a judge or jury. In some jurisdictions, a barrister receives additional training in evidence law, ethics, and court practice and procedure. In contrast, a solicitor generally meets with clients, does preparatory and administrative work and provides legal advice. In this role, he or she may draft and review legal documents, interact with the client as necessary, prepare evidence, and generally manage the day-to-day administration of a lawsuit. A solicitor can provide a crucial support role to a barrister when in court, such as managing large volumes of documents in the case, or even negotiating a settlement outside the courtroom while the trial continues inside. There are other essential differences. A barrister will usually have rights of audience in the higher courts, whereas other legal professionals will often have more limited access, or will need to acquire additional qualifications to have such access, as in common law countries in which there is a split between the roles of barrister and solicitor. The barrister in civil law jurisdictions is responsible for appearing in trials or pleading cases before the courts. Barristers usually have particular knowledge of case law, precedent, and the skills to build a case. When a solicitor in general practice is confronted with an unusual point of law, they may seek the opinion of counsel on the issue. In most countries, barristers operate as sole practitioners, and are prohibited from forming partnerships or from working as a barrister as part of a corporation. However, barristers normally band together into chambers to share clerks and operating expenses. Some chambers grow to be large and sophisticated, and have a distinctly corporate feel. In some jurisdictions, barristers may be employed by firms of solicitors, banks, or corporations as in-house legal advisors. In contrast, solicitors and attorneys work directly with the clients and are responsible for engaging a barrister with the appropriate adequate expertise for the case. Barristers generally have little or no direct contact with their lay clients, particularly without the presence or involvement of the solicitor. All correspondence, inquiries, invoices, and so on will be addressed to the solicitor, who is primarily responsible for the barrister's fees. In court, barristers are often visibly distinguished from solicitors by their apparel. For example, in Ireland, England, and Wales, a barrister usually wears a horsehair wig, stiff collar bands, and a gown. Since January 2008, solicitor advocates have also been entitled to wear wigs but wear different gowns. In many countries, the traditional divisions between barristers and solicitors are breaking down. Barristers once enjoyed a monopoly on appearances before the higher courts, but in Great Britain this has now been abolished, and solicitor advocates can generally appear for clients at trial. Increasingly, firms of solicitors are keeping even the most advanced advisory and litigation work in-house for economic and client relationship reasons. Similarly, the prohibition on barristers taking instructions directly from the public has also been widely abolished. But, in practice, direct instruction is still a rarity in most jurisdictions, partly because barristers with narrow specializations, or who are only really trained for advocacy, are not prepared to provide general advice to members of the public. Historically, barristers have had a major role in trial preparation, including drafting pleadings and reviewing evidence. In some areas of law, that is still the case. In other areas, it is relatively common for the barrister to receive the brief from the instructing solicitor to represent a client at trial only a day or two before the proceeding. Part of the reason for this is cost. A barrister is entitled to a brief fee when a brief is delivered, and this represents the bulk of his fee in relation to any trial. They are then usually entitled to a refresher for each day of the trial after the first. But if a case is settled before the trial, the barrister is not needed and the brief fee would be wasted. Some solicitors avoid this by delaying delivery of the brief until it is certain the case will go to trial. Justification for a split profession. Some benefits of maintaining the split include having an independent barrister reviewing a course of action gives the client a fresh and independent opinion from an expert in the field, distinct from solicitors who may maintain ongoing and long-term relationships with the client. In many jurisdictions, judges are appointed from the bar. Since barristers do not have long-term client relationships and are further removed from clients than solicitors, judicial appointees are more independent. Having recourse to all of the specialist barristers at the bar can enable smaller firms, who could not maintain large specialist departments, to compete with larger firms. A barrister acts as a check on the solicitor conducting the trial. If it becomes apparent that the claim or defense has not been properly conducted by the solicitor prior to trial, the barrister can advise the client of a separate possible claim against the solicitor. Expertise in conducting trials. Owing to the fact that barristers are specialist advocates, in many jurisdictions, barristers must follow the cab rank rule, which obliges them to accept a brief if it is in their area of expertise and if they are available, facilitating access to justice for the unpopular. Some disadvantages of the split include a multiplicity of legal advisors can lead to less efficiency and higher costs, a concern to Sir David Clementi in his review of the English legal profession. Because they are further removed from the client, barristers can be less familiar with the client's needs. A detailed examination of the justifications for a split legal profession and of the arguments in favor of a fused profession can be found in English solicitor Peter Reeve's 1986 book, Are Two Legal Professions Necessary? Regulation. Barristers are regulated by the bar for the jurisdiction where they practice, and in some countries, by the inn of court to which they belong. In some countries, there is external regulation. Inns of court, where they exist, regulate admission to the profession. Inns of court are independent societies that are titularly responsible for the training, admission, and discipline of barristers. Where they exist, a person may only be called to the bar by an inn, of which they must first be a member. In fact, historically, call to and success at the bar, to a large degree, depended upon social connections made early in life. A bar collectively describes all members of the profession of barrister within a given jurisdiction, while as a minimum the bar is an association embracing all its members. It is usually the case, either de facto or de jure, that the bar is invested with regulatory powers over the manner in which barristers practice.